But really, what's the difference? Why would we do that? Well, the point is that these all have different value and cost in terms of how quickly they can be prepared and filed, and what they actually would cost in terms of dollars to prepare. And so, we look at this first level. It's very low cost because essentially there's no attorney time involved, and it's very fast because again there's no attorney time involved, so it can be sent directly to the patent office. Now the problem with that is it depends. The value of that type of application depends very heavily on how broadly the invention disclosure is written. If it's written very narrowly to one thing that has been done in the laboratory, it can provide relatively limited support for a broader claim to the invention later on. And it could mean that if we're only relying on that application for priority, it could mean that our claims would be very limited and potentially not very valuable. We look at this next level as sort of the compromised situation here, where we're not spending a lot of time drafting a lot of supporting description to the invention, where we're relying essentially on what's been provided by the inventor, but we are spending time to write some claims. In this situation, we've got our situation is much improved. We can do something quickly, but now we actually have support for the claims to the broad invention that we want to make, and our ability to rely on what the inventor has done in terms of all the technical description of the work. That is a lot more reliable because generally these disclosures are quite comprehensive, and they essentially tell the skilled artisan, whether it's scientist, engineer, or otherwise, exactly what you need to do to reproduce the work. And that's the important thing that we need to support or meet from a description standpoint. What we can't fix or what we can't address later on is this idea of what describes the invention, what claims can we write for the invention. That has to be as accurate and as right as possible up front. And then, of course, the main compromise we see when we write the full application, of course, we're meeting all the requirements for patentability, but the bottom line is that just takes time to do. It takes time for the attorney to write a thorough application. It takes time for the inventor to review the application, and that back and forth can take periods of weeks or maybe a couple of months, depending on the schedules involved. And so even if there's a commitment to file something as comprehensive as possible, the bottom line is that can take time to get that done, and that's can be a risk there. The advantage of this type of process, and again, this is more towards the to the university view. These steps that I've outlined, it's not really a big overhead, not necessarily a large add-on to cost, because essentially these are the steps that any patent attorney is going to follow when he drafts a patent application. So it's not really additional work for me to stop at some intermediate point and file a partial product with the patent office with the idea that I know in a month or so I'm going to have the final product and I can file that as well. And also, as we'll see in the next slide, the university is receiving some, under the new laws, receiving some pretty big discounts for filing patent applications. So the add-on cost to file these applications that is charged by the PTO is actually significantly reduced, and the cost of this procedure is not necessarily a lot higher than what you might think for just filing a single application. And going on to the next thing, this is really sort of bad news and good news. The bad news is that fees are all immediately across the board increased by 15%, and the PTO has its authority to set its fees as it wishes. Going forward, generally, I would expect that to be in the direction of increased prices. I don't see them decreasing them, so we can only expect that to become more expensive from the PTO side. Now, the big plus to the university, however, is that it qualifies as, quote, a micro-entity, and it gets a 75% discount to everything. Right? So that's a very big plus to the university. And the only real requirement for this is that, one, you be a university entity, but number two, the university has to have already received the assignments from the inventors, assigning their rights in the invention to the university, or there has to be an obligation for all of the inventors to assign their rights to the university. And so as long as you can meet that last requirement, the university will be entitled to a very large discount on the filing fees. And of course, that's the message from the standpoint of the university, is to make sure that all of its employees and potential inventors are under that obligation. And from the standpoint of the inventors who are actually participating in the process, when you have papers from the attorney that relate to assignment of the invention, it's important to get those executed and returned as soon as possible, because otherwise the university ends up spending time and money on administrative types of details, as opposed to actually, getting a patent issued through the patent office. Some other features which are really sort of related to this, there's some other streamlined features. Again, these all sort of tie to the idea of getting your assignment in place. Currently, an invention is owned in the first instance by the inventor. So when inventors collectively or individually, if it's a single inventor, when they invent something, immediately ownership of the invention is shared equally among all inventors, and that's the way it works under U.S. patent law. It doesn't matter who you work for, whether you work for someone or working by yourself. Inventorship determines initial ownership, but the reality is that when a person is working for a corporation or working for a university, they have an obligation to assign the rights to their invention to their employer. That's usually the way it works. The patent law updates to the patent law recognizes this, and so it says, well, sure, you still need to identify the inventors when you file a patent application. It's important to know who they are, but the application can be filed directly in the name of the entity. So here, the application doesn't need to be filed in the name of inventors X, Y, and Z. It can just be filed in the name of Eastern Michigan University. And what that does is it sets the university in the first instance as the first owner. You don't have to go through this mechanism of filing the name of the inventors and then immediately assigning it to the university to perfect the university rights. So that's a large advantage for the university. It helps potentially deal with uncooperative inventors who either are unaware or don't agree with their obligation to assign the rights to the university. But more likely, a common situation is when an inventor is perfectly willing to cooperate, but inventors can be often difficult to locate, especially in the university setting. It's not uncommon for an inventor, say a graduate student, to be a co-inventor on some technology. An application is filed, the student defends his thesis and then returns to his country. And maybe a year later, it's time to file another application, and you can be very difficult to find that inventor, even though the inventor would have no problem cooperating with the university and in fulfilling all of his obligations. Just the fact that it can be difficult to actually do this and find the inventors after the fact, this puts the university in a much better situation where, again, as long as they either have an assignment or they can demonstrate that there's an obligation for the inventors to assign their rights to the university, they just file the application directly in the name of the university and not have to worry about tracking people down who may be difficult to locate. And so that's a very important message. I guess the second most important message is that the university should take advantage of this feature to streamline the process and eliminate some of the inefficiencies that can be involved with obtaining signatures and getting all of the ownership rights perfected in the patent office. But in order to do this, we need to be sure that it's very clear that all of the inventors have an obligation to assign. What we don't know yet is what the patent office is going to require to demonstrate this obligation to assign. I would guess that it's probably going to be something as simple as either the attorney or the assignee just signing a form that says, I certify that these inventors have an obligation to assign their rights to the university. Well, that's fine, but you need to make sure that that's actually true in the event that either the patent office challenges it or an inventor challenges it. So I think that would be very simple in most cases to implement, but the important thing is that all of the underlying documentation that makes it clear that there's an obligation that needs to be in place. Okay. All right. that ends the